That couldn't be further from the truth. We have the ability to opt out of it. And let me explain and show you how that works. So let's assume for a minute here that we have a standard married couple, okay? We have the husband, we have the wife. Husband has severe Alzheimer's disease. He's been living in a nursing home for the last 10 years. He's on Medi-Cal. Wife, through spousal impoverishment, which we talked all about in an earlier program, has, let's say, $400,000 in the bank and the family residence. He's receiving Medi-Cal benefits to take care of him. So what happens? Well, let's assume that she passes away first. What's going to happen? Well, in most traditional estate plans, what happens is the trust says, and this is a large enough estate where they likely have some form of trust, the trust says that when she dies, everything goes to him. And he just inherited everything. Now, what's the problem with him inheriting everything? Well, the first problem is that if they have $400,000, they are going to have him disqualified from Medi-Cal benefits and he'll lose his Medi-Cal. And that would be a major problem. So let's just assume, just for this piece of this hypothetical, that this $400,000 doesn't exist. Okay, that it's just the house. So what happens? She has the house, she passes away, the house transfers to him. When he dies, let's say 6 months later, what happens? Well, we want to file recovery because it's being transferred either by title or revocable trust or probate, and Medi-Cal comes in and says, we're entitled to get paid. Now, I know what you're thinking. That's really a problem. Well, let's describe what other solutions that we would have available to us. Okay? Remember, Medi-Cal only kicks in after the death of both spouses. There is no right for a lien, there is no right to do anything. So what happens during their lifetime? Is it possible for her to do something different? Sure. If she rewrites her estate plan, and we come out and we have the estate plan say, we're not going to give the money to him. Instead, we're going to have the money passed down to our children. Or we'll have the money go into a special kind of trust for his benefit. If we do that, number one, we'll keep Medi-Cal in place. We won't lose Medi-Cal benefits, and we'll continue to have him receiving the care that he's entitled to with the resources being preserved. And then critically, because the property, and let's assume it's going to the children, just in this example, because the property passes down to the children, and they now own this property, right? So now they own this property. When he dies 6 months later, what does Medi-Cal collect? It's really simple. Medi-Cal collects whatever he owns, which is what? Nothing. Recovery is completely avoided. Now, I know what you're thinking. That is a very clever plan. It's very, very clever. But he's the sick one. And he's the husband. So the likelihood of her passing away first is rather low. So what other options do we have? And so let me clear this board and we'll talk about that.